Hi, everyone, and thank you so much for joining us for today's event on Chevron 101, what it means for you as a congressional staffer in the short term. I am Marci Harris, and I'm co-founder and executive director of POPVOX Foundation. For those who may not be familiar with us, we work to support the Hill in pursuing innovation and making government work better, particularly with a focus on staff capacity and technology and building bridges across silos. We have a ton of resources for congressional staffers to use, including best practices guide, previously recorded events, and a few weekly newsletters. You can find all of that at popvox.org. This event is designed to help congressional staff get an understanding of what just happened with the Loper Bright decision and the Supreme Court's overruling of the Chevron doctrine. We will cover the recent ruling, some immediate effects on the Hill. We'll talk a bit about some of the misconceptions that are out there, and we'll take questions. I am joined by some experts, and I'm very happy to have them with us. I have Satya Thalam who is a senior fellow with the Foundation for American Innovation, and Soren Dayton, who's director of governance at the Niskanen Center, and I'll have them introduce themselves in just a moment. This event is being recorded, so if you have any questions, just submit them, and we will try to get to them, and we'll also share the recording with you afterwards. So with that, I am going to jump into a quick background slide deck, just to make sure we are all on the same page, because I think we all start at a different levels of comfort with some of the questions of with the recent decision. So let me drop into the slide deck. And we'll start with just where are we in the policy continuum? So as you all know, this decision that we're discussing has to do with the rulemaking process, has to do with what happens in agencies. But just to give you a visual of how the legislative process feeds into the executive branch, the rulemaking process, this is just a little bit of a helpful visual. So you know where ideas for legislation come from, lots of places, from members, from constituents, from advocacy groups, et cetera. That goes into the drafting process in the legislative branch, and then through the legislative process, how a bill becomes a law. And then once the bill passes both chambers, is signed by the president, it is over to the executive branch. And this is where lots of us in the legislative branch stop paying attention. This is where the rulemaking process starts. And we'll talk a little bit more about that in a minute. But once the rules are made, the executive branch agencies implement the policy. And then each branch has their ongoing role. The executive branch enforces, the legislative branch conducts oversight and appropriates money for the programs or policies, and the judicial branch engages in legal review. And that's really where we are with this decision. So what just happened? In two decisions on June 28th in Loper Bright v. Raimondo and Relentless v. Department of Commerce, the Supreme Court overturned a long-standing legal doctrine called Chevron deference, which was established in the 1984 Chevron USA versus Natural Resources Defense Council case. You don't need to know the details. What's important is that that case established a principle that when Congress has not directly spoken to an issue, or when the statutory language is ambiguous, courts would defer to the agency's interpretations of those statutes. So how often was this deference used? Of Of late, in recent years, not a lot. So Chief Justice Roberts noted in the Loper Bright decision that the Supreme Court had not deferred to an agency interpretation under Chevron since 2016. But Chevron was still a principle that was employed quite a bit in the lower courts as they considered various challenges to regulations and looked to see if agencies were acting within the bounds of the statute. Also important to note, the Supreme Court had kind of carved out an area of law that where it instructed courts to not defer in 2022 with the West Virginia versus EPA decision that established what's now known as the major questions doctrine, basically instructing courts to not defer on questions of vast economic and political significance without clear statutory authorization. Agency rulemaking, you may have played around on regulations.gov and seen the myriad regulations that federal agencies put out for public comment. That process and other elements of the rulemaking process is governed by the Administrative Procedures Act of 1946. That sets the rules for how federal agencies create regulations. And if agencies don't follow the procedures of the Administrative Procedures Act, those rules can be challenged and often are. Loper Bright was a challenge to an agency rulemaking. In this case, we won't get into the details too much, but the court was reviewing whether the agency acted within authority given to it by Congress. And in this case, the statute said that fishing vessels needed inspectors, but didn't say who should cover the cost of those inspectors. So the agency said that means the fishing company should cover that cost. And they challenged that and said, well, Congress didn't give you the authority to decide that. And the lower court said, well, we'll just defer to the agency. Congress hasn't addressed this. We'll stick with what the agency's interpretation is. And the Supreme Court, overruling Chevron, said that agencies should not rely on that in making their decision. So the holding in Loper Bright basically says that it is against the Administrative Procedures Act for courts to defer automatically to agencies, that job of interpreting what a statute says is something that the courts should undertake, that's what courts do. They interpret statutes. And so the Administrative Procedures Act doesn't provide any specific language telling the courts to defer to the agencies. And in the absence of that, the majority opinion says that the courts have to follow the same rules of statutory construction or in statutory interpretation that they use in other areas of law. So now the new Loper Bright standard is when statutes are ambiguous or silent on an issue, courts look to the rules of statutory interpretation to discern congressional intent instead of deferring to the agency's interpretation. And you can see the language there from the Loper Bright decision explaining the Supreme Court's interpretation of the framers' intent for the courts to exercise that judgment. These rules of statutory interpretation, they are what every law student studies. Rule number one is always to start with the plain meaning of the statute. And then it gets a little fuzzier. We have a very textualist majority on the Supreme Court. So that question of what do the words of the statute say is really the primary consideration for this Supreme Court. There are other rules that you see here for the interpretation of statutes. This question of legislative intent and how much deference or attention courts give to that differs by court. But ultimately, what the courts are looking to is what did Congress mean? What did Congress say at the time that the statute was passed. So what does all of this mean? Number one, just to be very clear on what it does and doesn't mean, courts cannot force Congress to act. Courts did not give Congress anything. Courts did not return any authority to Congress. I know that those words have been tossed out a bit recently. Congress has always had the power to make laws and clarify its intent. That is its Article 1 power. Courts must always follow congressional intent as they interpret it in the statute. The only issue arises when that intent is not clear. It's unclear or unexpressed. So under Chevron, when Congress didn't act, agencies filled the gap. Under Loper Bright now, when Congress doesn't act, the courts will act to try to discern what Congress intended. Congress can still delegate authority to agencies. So it is a misconception that that is not possible. The Congress just has to be clear what power is being delegated to the agency, what decisions they want the agency to make. And that has to be sufficiently narrow that it is not giving away the lawmaking power to the agency. That would be an unlawful delegation of lawmaking power. So a delegation should be clear, it should be narrow. And the question of what the boundaries are of that, what language is going to work for a clear delegation that doesn't violate the Constitution, that's probably going to be something that we hear a lot about over the coming months. Another thing that we're hearing in response is that now that Chevron's gone, Congress has to be super specific, and Congress is going to have to get in the weeds and make very detailed determinations of, standards down to the millimeter or some other kind of great specificity. And that's not necessarily the case. There's a difference in being specific and being clear. And Congress needs to be clear in order to address the court's concern about demonstrating intent to delegate certain decisions or create certain boundaries in statute. So this is just a made-up example, somewhat relevant to existing issues. But if Congress were to get really specific and list financial institutions that a certain statute applies to, and they said it applies to banks and credit unions, credit card companies, period, then that would be all that statute applies to. And it would exclude new institutions, new functionalities, new technologies that have not been contemplated. So instead of being specific, if drafters were clear, and instead talked about categories or characteristics, then you might write a statute alluding to financial institutions, including but not limited to entities that accept deposits, provide loans, issue credit, facilitate payments. So in this case, a broader definition would cover current institutions and probably be able to be interpreted by the agency and by courts to include new institutions or new technologies that were not contemplated at the time of the statute. Also, agencies can still interpret statutes and regulate. That's what they do. That's what they will continue to do. They are just going to have to be very intentional about building their case, building the record. There was an earlier standard for courts looking to agencies, even before Chevron, to use agencies' expertise in helping them decide how statute should be read. And that's the Skidmore case that Chief Justice Roberts referenced in Loper. And here he's quoting Skidmore, explaining that an agency's record can be considered a body of experience and informed judgment to which courts and litigants could properly resort for guidance. So That doesn't mean you defer to the agency, but it does mean that courts can look to the record that the agency is building as a very helpful body of work and expertise that they can reference. But also agencies need to prepare for new and existing regulations to be challenged. That's already happening. And to work with Congress to ensure that key policy priorities are enacted in law rather than through regulations. Another key point to keep in mind when looking at the Loper Bright case is that it only applies to future cases. The previous decisions based on Chevron, including the Chevron case itself, are not overturned. Those are still good law. But that means that existing regulations can be challenged with new cases, not overturning the old cases, but bringing new cases. And there are already many of those making their way through the courts. That potentially is even at a greater volume following the corner post decision on July 1st that found that the 6-year statute of limitations doesn't apply to challenges under the Administrative Procedures Act. So you can see here with the notice coverage, big law firms rightly understand that this is going to be a boon to their business. They are contacting their clients and talking about the quote unquote fresh opportunities to sue the government. So the volume is going to be massive. So what does it mean for you? Number one, prepare to be lobbied. The regulatory field is shifting to the legislative branch if Congress decides to take up that mantle. Well-resourced advocates are going to be turning to you as staffers in an effort to help build the record in committee. They will be submitting legislative language. They will be requesting to testify. They will be requesting that you submit, that your boss enter into the record reports, statements, articles, etc. Requesting that your boss sign on to letters to agencies. That may grow exponentially. Even comments on pending regs and requests to join amicus briefs for cases that are pending in lower courts. Talk to CRS, talk to the experts in the legislative branch who are there to help you. Ask which regs in your committee's your boss's committee's jurisdiction are already the subject of cases that are making their way through the courts. Ask for a briefing on regs that are potentially going to be challenged. And ask for training on statutory interpretation. It's something that we could all use a refresher on. When hiring, look for legal or regulatory background. Those folks are going to be hot and hard to find because they will be getting lots of offers in the private sector. So if you find someone with that kind of expertise and they want to work with you, hire them. Parse the language, build the record. Now is the time to think about courts as an additional audience, even as you are writing to get the votes to pass the bill, and you are thinking about the advocates and you are thinking about the members and how to get them to the table. You also have to think about the courts and how it plays there. And then a last point is also to just vet potential public statements to ensure that they hold true under myriad electoral outcomes. Make sure that what you're saying about what an administration does is the same thing you would say if your candidate of choice or party of choice is not the person sitting in that seat. The issue here is no longer should Chevron be overturned. It has been. The issue is how can you advance or protect your boss's priorities in this new environment. So with that, let's talk to our friend Soren Dayton, Director of Governance at Niskanen, and Sadia Thalam, non-resident Senior Fellow at the Foundation for American Innovation. Fellas, what did I miss?
Marci, that was amazing. And I think especially that process arrow that shows the different stages of the policymaking, we economists call it a production function. I think that's what's literally illustrative because there was no illustration, but it's illustrative in the sense that you think of your job as a staffer as part of a longer process. And it actually, the arrow could kind of be like circular. And I think that was sort of implied by it. This is a process that flows from the idea stage all the way to review, and then sometimes back again as Congress sort of reconsiders, does oversight, updates statutes, and so on. And that was a big lesson for me as a staffer, especially at a committee. The first time that I was the lead on a piece of legislation that ultimately was passed by Congress and signed by the president to law, I thought, great, my job is done. I'm gonna go. I'm gonna go have a beer. Back then it was Romeo and Juliet was the bar, the patio. Um, and then a more experienced colleague turned to me and said, "No, no, no, your job is just beginning, because now you have to get the agency to actually do the thing that is written in the law. Laws are not self-executing. And even where you have worked with an agency and they are favorable to the law that you have drafted and amended and gotten signed into law, even where they're supportive and they were working with you to advance that effort, it's still not go. You can't just sort of rely on, well, it'll figure itself out. The agency knows what they're doing, and then our job is done. It's your uh, almost like fiduciary responsibility to your member of Congress, the elected official to whom you work, to continue to conduct oversight, to maintain relationships with the agency, to get more information, to gather, and ultimately to revisit the issue if that's what it comes down to. I'd also note another thing that I learned on the congressional side of Pennsylvania Avenue was um, there's been a kind of common refrain complaining about Congress that Congress doesn't pass laws, they pass frameworks, they leave all this ambiguity. And of course, Chevron step two is necessary because almost all statutes have some level of ambiguity in them. I'd make two, and so that conclusion is true. I disagree with the premise that this is a problem. One, no person, it is an impossible task to with complete specificity and foresight to make policy. You only ever have the information at a given point in time. Um, the example that you gave, Marci, of financial regulation, there was no way for um, those authorizing organic statutes of financial regulators to have anticipated what cryptocurrency is, right? At the time. This is an ongoing job. You have to revisit. It would have been impossible unless Satoshi was working for your committee to have said, oh, we should probably put in cryptocurrency when we list types of financial transactions, right? That's just impossible. So that's an impossible goal that's not achievable. So that's a necessity, just given our bounded rationality. The second part of it is sometimes that ambiguity is a feature, not a bug. Many of you have possibly been in a conference room with folks from other offices negotiating language to be adopted by a committee or negotiating amendments. And what happens? Sometimes the easiest outcome is to say, let's leave it ambiguous, let's leave it blank. Maybe we'll put a footnote in the committee report. Maybe we'll have back channels with the agency and tell them what we meant, but we couldn't come to an agreement. The more specific you are, the harder it is to come to an agreement. So there's a trade-off there. And sometimes that ambiguity is not because good staffers like yourselves don't know what they're doing. It's because it's between this bill not going anywhere and the issue is dead, or this is the best we could come up with, and we're going to have to do a little bit of hand waving so that different members with different ideologies can ultimately support the bill and get it advanced. Those are only two things I would.
That's fantastic. And I think, so interestingly, what you were describing, with that continuum actually being a circle, one of the things that we don't do, at least formally, very well, is that interaction between staffers and agencies. I mean, really, in so many ways, it comes down to personal relationships rather than any kind of formal channels for information sharing between the agencies and Congress. Except, perhaps sometimes the secretary comes to testify at budget time, or an oversight hearing or a GAO report. But as far as ongoing feedback loops between the agencies and Congress, it seems like that's going to be something that really needs to happen in the wake of Chevron. Doran, what did we miss? What else is on your mind on the background?
Well, I'd make a couple more comments. I think these are very consistent with what's been said. The first one is, I think there's been, I want maybe a little bit of an overreaction or a sort of overreading. I don't think that's happened on this call, but an admin law professor at University of Michigan, Nick Bagley, had a tweet thread of all the regs that were published in the Federal Register the day that the Loper Bright, sorry, COVID mouth, COVID brain, COVID throat, the day that it came down, and none of them were plausibly put in question by the Loper Bright decision. So I think this did not kill the regulatory state. This did not kill the administrative state. The reason we've gotten into some of these uncertain cases is that we're dealing with, as I mentioned earlier, old statutes that people haven't revisited how they get implemented. And so I think one of the questions for Congress is, how does it do that on the front end, and how does it do it on an ongoing basis? I think Satya has given some important examples. One thing that I would really love to see come from this is an opportunity to make subcommittees great again, right? Like, subcommittees are a place where Congress has done a lot of work in the past. And I think in the leadership-driven culture that we've had in the last couple of years, especially in the House, we have had fewer subcommittee hearings and markups on these hard issues. And I think we could do more of that to really clearly articulate what the problems are, and frankly, also give your bosses some more work to do in a good way, and really get them deep on these issues. And of course, that means getting you deep on these issues too. This is probably one of the most important vehicles we have for really digging in, bringing in more experts. I doubt you're going to get agency heads at a subcommittee hearing, but I think you can get a lot of other people that know these issues deeply and can articulate the kinds of problems you're trying to solve. So on the record building part, I think that's a really critical thing. And then one of the lessons, especially on subject matter where there's really strong constituencies for maintaining a program, people should think about the power of sunsetting programs, right? I mean, not every issue is as powerful as like the 702 surveillance stuff, where there's a strong national security infrastructure. But the fact that gets sunset every handful of years means Congress revisits it, means there's changes in the programs. And I think when you have changes in when Congress gets to update statutes like they do on transportation, or like they try to do on ag and things like that, you just create fewer opportunities for doing this. I think to switch slightly to a major questions doctrine thing, the cases that's come up has been sort of 70s, 80s era, really 70s era statutes around how to interpret the Clean Water Act and things, or the Clean Air Act. And that's, probably the answer is we shouldn't be using 70s era statutes to regulate emissions today. We should have new statutes. We should, and the Telecoms Act, maybe, our last Telecoms Act was 96. Maybe we should update that. Then you wouldn't have as many open questions. So I think those are the kinds of things that we're going to need to do. Figure out how to build the constituencies to do this. Some of that's on the outside advocates like us. But a lot of that is going to be you all pushing. And I think one way to do that also gives your bosses a lot more of a platform to take a leadership role on this is leveraging the subcommittees.
I'll add another thing I just remembered about this. Two things about the idea of Congress ought to be expected to fill in all the blanks. I think it behooves Congress to do so, but don't really require to. I think the implication of the court case is not that, as Marci alluded to in the presentation, this is not a reassertion of congressional authority. It's an opportunity, but Congress always had that opportunity. And in the absence of that, courts will make those decisions. I'll also make a aside about the idea of congressional intent. For those who are lawyers, for those who've gone through law school, statutory interpretation is a big old knotty subject with all kinds of debates about how it's done. I remember one of my colleagues on the Hill, Soren may know him. I don't want to blow up his spot, but he clerked for multiple associate justices of the Supreme Court. This is a very, very smart, savvy guy. Knows he was a smart law talking guy. And I remember one time we were sitting in the anteroom of the committee hearing room with agency counterparts negotiating somewhat significant substantive change in law. And we arrived at one of those moments where we couldn't come to an agreement about the specific wording, the clarification that we wanted to make in the text of the positive law. And we did one of those things where we said, well, you know what we mean, and I know what you mean. Why don't we put something in the committee report and we'll know what that's meant to mean, and so on. And he stopped and he said, if anyone wonders why certain judges hate the idea of congressional intent, it's this right here. It's us sitting in a room saying, well, so I would just caution that I wouldn't get too bogged down on the idea of trying to establish congressional intent. But to Marci's point, everything that is made public is subject to review, and any court may decide that that's relevant. A member statement on the floor, committee report, footnotes, hearing records. You don't know what's ultimately going to make the case on your behalf. So be careful with them, be deliberate. Remember that nothing is tossed off in the sort of like long sweep of history. You don't know where that in quote interpretation could come from.
I want to emphasize that, there are a lot of meta conversations about how Congress can deal with some of these changes. But one of the things we really want to focus on in this session is the day-to-day for the average staffer, and what kinds of tools, what kinds of volume can they expect coming. And Satya, just before the decision came out, you and Dan Lips wrote a piece entitled "Congress May Soon Have More Homework." So I wanted to toss it over to you one more time to just ask, what kind of homework should staffers be thinking about that this decision implies?
This is also a timely event because I'll also be testifying on this very topic on Tuesday before the House Committee on Administration, which is exclusively focused on Congress and policymaking environment post-Chevron. So homework, using the word homework might have been a little flippant, but if to sort of torture the metaphor a bit, it's not homework like a requirement. This is what I was saying a second ago. Think of it as right now, Congress is auditing the class, right? Congress can choose to do the optional assignments, and those assignments are getting smart about regulatory process and the administrative procedure and how interagency processes work. So one of the things that it's hard for an individual staffer to solve this problem, but beyond relying on CRS and GAO, who are both legislative agencies, they work for you. It is their job, it's in their mission to work on behalf of legislative staff, on behalf of Congress. But we need more staff within the committees. We need folks that understand the administrative process. And we need, for the existing staff, if that can't happen, to take a more active role in following agency rulemakings, keeping an eye on them, being willing to comment or solicit your constituents that have a particular interest. So if the bill that authorized a rule came from a constituent that said, I'm having this problem and I think this agency can solve it, can you help me write a law? It's your prerogative and your responsibility to follow then what the agency is doing, to intervene to the degree you can. Agencies are led by political officials, so they are sensitive to when a member of Congress, especially a member of the Committee of Jurisdiction, is concerned about something. You don't always have to resort to a public letter. Oftentimes, a phone call with a sub-cabinet official is the right place and can actually result in the outcome that you want. Also, understanding how the interagency process works. So a lot of folks may not realize that for most significant, I'm using that in kind of a vernacular way, just things of a certain import and scale for regulations that are being proposed in development, the agency doesn't just develop it and then publish it. It goes to the White House for review by all the other parts of the executive branch that plausibly have what we call an equity, that may have some plausible say, either because they have some expertise, or they have their own constituents that may be affected, or their own authorities may be jeopardized by this other agency pursuing a rule. A rule that I worked on early on was the so-called hemp rule that legalized, federally legalized the subcategory of cannabis called hemp. The FDA had an interest in that rule, even though it was a Department of Agriculture rule. The DEA had an interest in that rule, even though it was a Department of Agriculture rule. The State Department, believe it or not, had an interest in that rule because the U.S. is part of certain international treaties on narcotics. So know that your leverage point is not a single person in a single sub-office at an agency. Know that your leverage point is also other agencies. And finally, to Marci's point about looking ahead and not necessarily being tied to who's running the agency now. Maybe they're your ally. Maybe next time around they're not. But you can still be ideologically opposed and establish productive relationships with both careers and politicals who may not be obviously, quote, on your side. You are a source of both help and potential a potential problem for them, and no matter where they're coming from, they want to resolve that problem if they can. And I think so much of what we see now is because Congress sees its work as being done once the president's signature goes across the bill. Anything that comes up later on, they think, well, we don't have any say, so I have to make as much noise as possible and I have to be as much of an irritant as possible. Maybe that's the case, but it's not always the case.
Our friend Jen Paga calls that pass a law, throw it over the wall, and really never think about it again. And I think that kind of feedback loop is something, to your point, Satya, that makes that really is essential. Soren, I want to pass to you and ask and kind of follow up on a question that we've got in the chat, and I invite all attendees to share questions if you've got them. What Satya just described about the interagency process and full expert agencies weighing in, and even how that process happens. One of the questions that we've got is, how well do members of Congress and staff understand how federal agencies operate and understand the weeds of these programs? So I think that's probably a little bit of a meta question, and I think that the inference is that they don't understand the weeds. But Soren, can you talk a little bit about what that relationship? I mean, you don't have to understand the day-to-day weeds to legislate, but a feedback loop, what that should look like, and you know, how much Congress does need to upgrade its understanding of some of these federal agency processes.
Well, I suspect in many cases the answer is sadly, you know, or is maybe not very well. But I will tell you, as someone who sits in a think tank, who, um, we work on a wide range of issues. When something gets passed, our next question is, are there regs going to be implemented? Who's going to be doing something to make sure that like it's staffed, right? That Satya said it's not self-executing. Like they may not even have the headcount or the management structure to manage the program. And and there's many programs, there's many programs that are authorized for which there's no appropriations, and so you're already going to have to fight that fight, and that's already in Congress's role. But you ought to make the phone calls to figure out who's running the program, what's happening, things like that. And that probably means you're going to have to learn a little bit more about how the agency runs, and that's great because but a couple of points here. One, CRS understands some of this, GAO understands some of this, and look to your partners that helped you do this. I will tell you from my time, both in a think tank and in a sort of pure private sector role, like passing legislation, believe it or not, was like only a third of the task in getting something implemented. And we understood that. I think there is a shortage of that information. One thing that hasn't come up with, here is, for things for which there is going to be a public comment period, I actually don't see that many members file comments. Like I thought, I think if you had, and I kind of wish it weren't, I wish there were other tools for this, but it's the one we got right now. I think if you had like the chair and ranking of a committee or a subcommittee say, this is what we understand this deal to be, I think that would have an enormous impact on the regulatory process, what comes out of the rulemaking. And frankly, it would also be a great signal to the courts in the future. And, and that could be an evolving understanding. So I just, don't forget all the tools you have, whether it's the informal ones, like Satya mentioned, the tools on the appropriation side, other more formal record making you can use. All of those are going to have to happen. And sort of to where we started, you're going to have to go back and make sure you actually think about what implementation looks like, and find people that used to work in the agencies in the past. I mean, I understand we live in a sort of red and blue team city right now. Like find someone that you can talk to who is a political in that agency, and you'll get a lot of information about how this works. And in many cases, they won't even care. For most nonpartisan issues, they won't even care what the political alignment is. But for ones that are important, find them on your team.
There's that kind of cues up a related question that Colleen asked about the relative weight that courts will put on the public remarks, statements, and terminating legislative intent. I mean, so I think the short answer to that is it depends on the court. Again, this statutory interpretation has been a subject of debate since the 19th century. In Marci's presentation, she alluded to this particular Supreme Court is dominated by highly textualists, so that points to a certain type of canon, but not every court. This decision does not necessarily force lower courts to adopt their canon of statutory interpretation. But I was cued from this question because Soren noted, so I don't know how courts will weigh relative statements, press releases, but a comment in the regulatory docket on a rule by a member, or especially a committee member or subcommittee chair, that is that's a buy opportunity. Like that is an undervalued stock, and I don't know why. Now it takes time to do those things and to do them well, so it's easier to release a press release or to do a short oversight letter, but a comment on the record, it's not beneath a member of Congress to do that. In fact, it's where they should be, and you better believe a court will, or at least a sympathetic plaintiff, for instance, is going to put that front and center and front street a member of Congress saying this is not consistent with how when I drafted this bill, or when I sponsored it, what I thought it would do. Or alternatively, this is very much what I was hoping you would do. Please do more of this.
Yeah, I love that, and I love Soren's suggestion that it would even be more powerful as coming from the chair and the ranker, which I think gets to Cody's question of, you know, lots of discussion about Congress stepping up with statutory language or sunsetting programs or refining programs or getting specific or clear in new legislation. But in the polarized environment, to Sadia's point earlier, ambiguity is the friend of getting the votes. And so I guess we all know that that's the universe we're in. And we all know that, you know, to Sadia's earlier point, that's why ambiguity was such a good tool in the past. Do you think that this is going to lead to a forcing function for Congress? Are either of you hopeful about, you know, perhaps smaller, more targeted bills or technical corrections, or getting together in ways that Congress hasn't been incentivized to do before?
You know, Congress is not, well, Congress is its members, right, and its staff. And I think to some extent, the question is going to be how much you drive it. And I think a lot's going to be determined by what actions both the executive branch and the courts take in response. You know, and I think there's a lot more uncertainty about what Loper Bright means right now than there is certainty. And so I think we're going to need to see in outline what the courts do, and that may create some real fire, under people, as it were, to force them to do more. But I think you have an opportunity. And, I think we've talked about a couple of tools at the disposal here that you can do that only sort of require sort of leadership buy-in, right? Like more subcommittee action, more filing, statements, filing public comments, as Satya has noted, really getting involved in the implementation process. But I think if there's a big response, it's probably gonna, it's not gonna happen immediately. It's gonna happen once we see what, the implementation looks like, in the sense of how the courts handle these things moving forward. And there's at least an argument. I mean, there's a conservative admin law professor, Adrienne Vermeulen, who said, like, basically we're going to move from Chevron deference to a Loper Bright, I forget what delegation. Like, we're going to have just a very similar framework that's not going to change that much. Especially given you had the major questions doctrine, and Chevron was sort of a dead letter at the Supreme Court anyways. So I think we're just going to have to see. But if more court decisions come, I think it's going to raise the pressure, and y'all are going to be on the hook for figuring out solutions. And here's some tools today, and there'll be more in the future.
That's great. And Sadia, over to you to finish this up. We have additional questions about how members can respond if they think that a reg is being promulgated or carried out in a way that they disagreed with at the time of enactment. I think we talked about a few of those tools, but just if you could address that a bit more broadly and any summarizing thoughts.
I think I was looking at that one, and also the second part about the premise being Congress has trouble passing even so-called must-pass, like annual authorizations. Why would we then kind of play with fire with automatic sunsets? Some people believe that the Congress's inability to do things that used to be fairly routine, that failure is due to structural problems in Congress. I don't want to wave that away. That's probably partly true. But like with anything, I think we've just lost the the muscle memory. And I think the more you do a thing, the easier it becomes. The implied transaction cost goes down, and you don't walk into a gym and put 4 plates on each side of the barbell and try to do a deadlift. Like, you work your way up to it. So I wouldn't be fatalistic about, well, we can't pass things, why would we put ourselves in a bind? It does force, sunsets force the folks to the table, and it can be kind of gnarly, but that's part of the process, and we have to start somewhere. The last thing about could a member provide guidance on their intent? Absolutely. I mean, but this is the problem. I think people think their only opportunity to comment, and I mean not in the rulemaking, but just comment publicly, is after everything has been finalized and promulgated and it's now gone into effect. And that's when members either hear about it or they think, well, what was I going to do? It wasn't finalized. You are absolutely entitled. Remember, these are delegated authorities to the agency. These are Congress's authorities that they have said, we are allowing you to exercise on our behalf. But so it's not like they now have ownership and you're not allowed to say anything. Of course you are. However, it's unclear as far as courts, again, like, congressional intent's a very many splendored thing, right? Is it, when we're trying to decide congressional intent, is it all members of Congress together? Is it the chairman of the committee of jurisdiction? Is it the sponsor of the bill? We don't know. But there's no, you're not going to be any worse off by speaking up early and frequently.
Thank you so much, Sadia. That is, I think, a great way to wrap. Again, I apologize for the technical difficulties on this call, but really thank you all for hanging in. It's been a great discussion. We will share the slides. We'll clean up the video a little bit and share it with you as well. I strongly encourage you to catch the testimony in the Committee on House Administration next Tuesday, where Sadia will be testifying with others. And we will keep updating with links and resources and other articles that are out there. If you want to drop questions our way of topics that would be helpful to have covered, we will be very happy to facilitate. So thank you all for joining, and good luck. And thank you so much, Taylor, for coordinating, and Soren and Sadia for sharing your expertise. Take care.